So we are group one. My group mates are Michelle, Sydney, Gizelle, Brittney, and I am Bianca. And we will be discussing the case of Stanley versus Illinois. Introduction. Peter and Joan Stanley lived together on and off for 18 years and had 3 children together. During those 18 years, they never married. When Joan passed away, the state of Illinois took the custody of their 3 children because of the state laws assumed the reason for this custody was either neglect or dependency. Therefore, the state law mentions that unwedded fathers are automatically considered to be unfit guardians for their children. In 1971, Stanley went to the court to fight for his children's custody. The prosecution argued that unwed fathers are unsuited to raise children because they are financially unstable, they may abandon, or they can abuse or neglect their child. Because Stanley asked for assistance from a trustworthy family friend, the Nesses, he was considered unsuitable, unreliable to take care of their children. The state offered Stanley to file for adoption. They as well informed him that if he were to marry and maintain the relationship, there was a possible chance of custody. As for the prosecution, Illinois violated the Equal Protection Clause of the 14th Amendment, stating that no state can deny any person within its jurisdiction and equal protection of the laws. The state as well violated the Due Process Clause, meaning that because the state did not have a process of taking away his children, Stanley was able to have a hearing to keep custody.
Court decision, describe who's impacted, why this is a landmark case. There was unfairness towards fathers who were not married, as they were denied a hearing and automatically viewed as unfit. The state of Illinois kept children under their care when the mother passed away, since their fathers were not married to their mothers. Prosecutors also stated that Stanley did not have the means to care for his children, which prevented him from having custody. Stanley claimed this was unfair, and his case was then held in the United States Supreme Court. The Supreme Court ruled 5-2 in favor, considering that Illinois law violated the Due Process Clause, taking away parental rights from unmarried fathers. Stanley won his case as the Supreme Court recognized unwed fathers to have the same rights as married or divorced fathers. Fathers are impacted as they are denied a proper hearing of parental fitness, which automatically determines the custody over their children. They are also impacted as they are deprived from caring for their children simply for not being married to the mother. This is a landmark case because it gave fathers the opportunity to demonstrate that they are equally fit as mothers regardless of marriage. Opinion of landmark case. Justice White's opinion on this landmark case was that Stanley cannot be judged simply for not marrying his children's mother after caring for them all their lives. He believes Stanley should have the possibility to show he has not been a careless father. The author who reviewed this landmark case stated it was progressive, as children should not be taken from their father's care without a proper hearing. The author also agreed on having gender-neutral parenting, valuing caregiving regardless of who performs it. The state should also take an active role in supporting single parenting, co-parenting, and extended family care regardless of marital status. The constitutional law of family discriminates against race, class, and sex, and the author recounts historical accounts of constitutional litigation campaigns targeting non-marital children and their parents. With Stanley winning his case, it made way for programs like Aid to Families with Dependent Children, as they were highlighted more and used to help children kept away from their parents. Overall, Stanley's case was important for the process in the right direction for father and children primary custody law.
So I'm going to be talking about the policies stemming from Stanley versus Illinois. So the policy that came of this is the Uniform Parentage Act, or the UPA. It was introduced by Harry Krause. He was a law professor at the University of Illinois, and he was an advocate for family law, specifically with people of color. The goal of the UPA was to establish legal relationships between unwed fathers and their children. Because at the time, the state of Illinois, unwed fathers weren't considered legal parents, and they weren't recognized as parents. They were already just claimed unfit. And it was originally designed to help people of color, but it soon expanded to include all unwed fathers, regardless of your color, your ethnicity. And the services that the UPA provided to unwed fathers included genetic paternity testing and help with also getting parental fitness hearings. There is currently 2 versions of the UPA, the 2002 version and the 2017 version. All states have to adopt a version of this, but not all of them have the same one. A lot of the Midwest states do have the 2002 version, and a lot of the more liberal states carry the 2017 version. So the program stemming from Stanley versus Illinois is the Aid to Families with Dependent Children, or the AFDC. It was established under the Social Security Act of 1935. The goal of this program includes reducing poverty and helping families maintain a livable income. And there are some requirements that you do need to meet in order to use this program. And it includes being a family with dependent children or having an absent parent or disabled person in your family. Your income must be below 185% and having all assets be equal or less than $200,000 or $2,000.
The policy SWOT key points for the UPA. The strengths are for unwed fathers to seek potential parental rights to remove bias from children established by their parents' marriage condition. The weaknesses of the policy does not consider parents that are the same sex and give them both the legal rights. The opportunities were granted in July 2000 for fathers who were not the birth fathers the opportunity to be viewed as a parent. The threats of the policy for children being left without emotional and financial support from one parent because it does not include the same-sex parents of marriage.
Now, let's discuss the strengths, weaknesses, opportunities, and threats of the program. Before the AFDC program and other Social Security programs, the government mainly left family welfare a private concern, and the Great Depression of the 1930s left an unprecedented amount of unemployed Americans living in impoverishment. A positive attribute was that the AFDC program reinforced scattered existing state programs. This means that AFDC placed all scattered programs under a single federal umbrella, and this change also established uniform standards for the states. Just as there are strengths, there are also weaknesses to the program. The weakness of the AFDC program is what led to the creation of the Temporary Assistance for Needy Families, also known as the TANF program. The specific negative attribute of AFDC, TANF corrected, which was ending welfare as we knew it, when passed in 1996 under the Personal Responsibility and Work Opportunity Reconciliation Act. The TANF program closed the indefinite period of time for an individual to collect welfare benefits, and the public favored TANF programs benefits more than AFDC program benefits. A future positive attribute is definitely the program correction from AFDC to TANF and how TANF addressed the real problems with AFDC. Unlike TANF, AFDC disincentivizes individuals to work. The program essentially discouraged saving since there was a limit on assets. This means recipients were becoming heavily reliant on the program rather than aiming to put themselves in a better financial position. A potential problem that could end TANF or be problematic for the people TANF aims to assist is if the same problems that contributed to the creation of TANF were to occur again. Hence, the problem that contributed to the creation of TANF was the growing wealth inequality gap. Moving forward, let's review some suggested recommendations for the program. The first recommendation would be to implement opportunities for families to become self-sufficient. The implementation of such opportunities can be facilitated through different job opportunities and training programs. A second recommendation would be to stop enabling TANF recipients to rely heavily on program benefits. What is meant by this recommendation is that recipients of TANF benefits should be encouraged to evolve their financial resources and knowledge. Which leads me to my next recommendation. Create awareness and educate recipients of the employment and training activities provided to help them achieve self-sufficiency. When individuals have access to these types of resources, they are provided with different work and career opportunities. Essentially, using these resources can and will improve their financial position. The final recommendation refers to how, regardless of the socioeconomic status of a family or the marital status of the parents, families should continue to be supported by the local, state, and federal governments.
What are the implications for children and families given the state of things now and today? For the TNF program, does not consider the structure of families when aid is granted. Many families that receive aid are single parent families household, leaving married couples households out of the loop for receiving aid that is needed. The TNF program needs to be adjusted to fit all of the family's needs living in a single parent household or with a two-parent household. The federal government should draft new systems with guidelines to support the TNF program. Every child deserves a home, a hot meal, somewhere to lay their head, regardless of their parents' income. The TNF program can improve on helping families in the United States for aid.
So now we're going to be talking about what an ideal policy would look like. As a group, we came up with a few suggestions. So first, an ideal policy would consist of fathers being equal to mothers, even if they are not married. Both the mother and the father should be equally responsible for their child, and marriage should not determine their parental responsibility. Next, an ideal policy would consist of social programs and laws to enhance raising children, reproduction, and promote healthy families. Another way to improve a policy would be to allow parents, whether male or female, transgender or non-binary, being able to have a family and be able to live together without losing custody. Another suggestion is avoid discriminating the family structure of a household in any regard. And finally, an ideal policy would include providing financial assistance to unwed fathers who are fighting for custody. Now we're going to be talking about what an ideal program would look like. First, an ideal program would look like implementing procedures to educate families with children how to obtain and maintain a livable income. Next, we have resources to help parents ensure that their children are provided with care while they're working. Another suggestion we have is including education on LGBTQ families. Another suggestion would be having safe and nurturing environment promoting development of young children. And finally, an ideal program would be funding for families and providing assistance to those who are in need of guidance to maintain a stable family. These are the references that we use throughout our entire presentation. Thank you guys so much for listening, and we hope you enjoyed.